Next.
Serial number 31
and 16.
I appear for the respondent number, private respondent number 18 to 21.
This writ petition, lays challenge to illegal conversion of water bodies. There is a water body called Bagher Canal. This forms as the principal drainage system in respect of at least 3 municipalities. The present writ petition is concerned with one of them, that is Halisar municipality. The two other are Kachrapara, and there is one more. There are 3 in total: Halisar, Kachrapara, and Kollani. This writ petition is concerned with Halisar municipality. This Bagher Canal, a portion of it has been allowed to be converted into commercial and homestead land. A hotel has been allowed to be built upon it.
Hotel Dreamland.
Hotel Dreamland. Now, the writ petitioner writes to the district magistrate saying that this is the state of affairs. The district magistrate orders an inquiry. The BLNRO files a report upon RTI information being sought for. The report is in absolute conformity with what the private respondents would have wanted. The municipality is forwarded that report by the district magistrate only to give its comments. It is then that the tiger comes out of the bag. Your lordship will kindly take page 50. Page 50 is my RTI. Now lordship will kindly take the BLLRO's report on the RTI. Page 65. He has only gone on saying that it has been converted, it has been converted, it has been converted. Therefore, as if all the conversions are permissible, I shall take your lordship to the laws also.
Howrah Municipal Corporation has...
The municipal corporation, page 66. Rather, page 67. Halisar municipality. It makes its comments on the inquiry report. This is 5th of August 2024.
At page
67.
203, there is an order.
203, is an FIR. Lodged, by the Halisar municipality to the police, alleging, there is...
Conversion orders have been passed by the appropriate.
That is why, I have said, this, if, appeal, I cannot, lordship will kindly see, if this is the state of affairs, kindly have a look, at page 67, what the municipality says. Kindly have a look at this, which is why, I brought it by way of a public interest litigation. Lordship will kindly see this. If this is, how, the land reforms authorities deal with it, kindly see, the comments. 1. Messrs. Hotel Dreamland Premier has been constructed on Dag such and such, is owned by Shri such and such, such and such. As per LR record of Malik Bagh, Mauza character such and such, Dag number 6 is Khal, 9 is Doba. Out of the area belonging to Dag number 5, an area of such and such acre has been converted to hotel by order of learned such and such has been converted to Bastu land from Doba by order of learned ADMLR, but physical no activity of hotel takes place there. Out of the area, 2 is important. Discrepancy has been noticed in Dag number 6. As encroachment has been done by more or less 1 satak of existing canal, Khal. This Khal, forms the principal drainage system. I have made averments in my writ petition. If your lordship kindly takes my writ petition, kindly take paragraph 4. It says that there are no other big drains available in this area, and the Bagher Khal is the only source of connection with irrigation canal in the said areas and the Ganga river water, and the said canal is also responsible for maintaining underground water level. It should stop at some stage.
I am for the municipality. I have issued demolition order. I have also revoked the trade license. There is deviation. They have also submitted a forged plan and obtained illegal electricity connection. For that we have also lodged a GT. But only predicament of demolition is that they have filed a writ petition which is pending. That is the only predicament. I am law-abiding municipality, and I have taken my lordship will find also. Page 71 is the demolition order. So I have issued the demolition order.
Is there any stay granted in the...
No stay. My lord, I am appearing for the private respondent number 18 to 21. Previously, that order of conversion was granted in 1999. And the allegation as cancellation of trade license, no hearing was given to me, and I have no idea that there is a cancellation, because no notice has been served upon me till today.
See, there are 2 limbs to it. One is they say that the conversion could not have been done. The other is there is a encroachment in a canal.
No, at page 129 in this petition, they have given a no objection. Halisar municipality was granted me a no objection certificate.
See, that's what they say in the police complaint. If you see page 203, we are of the page at 205. We are of the view that the forged revised sanction plan respect of premises has been similarly placed before the other government departments concerned in order to illegally and unlawfully obtain license and permission so as to so and so. We are also the way to so and so Devendra Singh and Ramjit Singh possession of original forged revised plan in respect of so and so, at the time of applying souls, they themselves furnished a copy of the forged revised plan. It is also your kind attention so and so, or a portion of counterfeit seal of Alisar municipality.
Lord, this calls for an inquiry at least, Lord, at least an inquiry.
let
Lord,
them
this-
demolish.
Yes. Yes,
My lord.
I am just waiting.
Lord, Lordship will kindly have a look at the rule, Lord. West Bengal Land Reforms Rule
My lord.
459, 5A9. Lordship will kindly see this, and Lord, I shall take you, Lordship, Lord, to the conversion certificate, Lord. Lordship will kindly excuse me, Lord. I have only one copy, Lord, of the rules. Kindly have a look at the rules.
We are just
Lord.
waiting, my lord. Just if something happens, my lord.
Lord, kindly see, Lord, sub rule 9. Lord, compensatory water body has to be given. Lord, nothing of that sort done. Nothing. Lord, today, my Lord, underground water is a menace today.
No.
Shortage of it.
Normally, when a conversion order is there,
But
that
that was
condition will
dated
be-
Yes, Lord, I'm
1999.
showing the conversion order to your Lordship, Lord. Kindly have a look at the conversion order. Lord, kindly take, Lord, page 143. Without prejudice, without prejudice, without prejudice. My Lord, this is all, my Lord, that arraigns, my Lord, the conversion order. My Lord, page 144. Kindly have a look. Page 144, my Lord. My Lord, just the second box. Previous classification, ROR Khal. Classification after conversion, hotel.
That was given in the year 2016.
Yes,
I'm
no, I am not supposed to know this, my Lord. I could know only because of this writ petition, my Lord, which was filed, from where it appeared, my Lord, that entire thing is
And
illegal.
my lord-
And when I made my, my Lord, representation before the district magistrate, Lord, it is a question, Lord, of grave public importance. Lord, today, my Lord, water body is being filled up, constructions coming up, Lord, just maybe a few days back, my Lord, a building, my Lord, in my Lord, I mean, I think, my Lord, yes,
There are several other buildings, not
Neta-
only my
Trumbull.
not only my hotel.
But normally, this conversion order, they have that condition. Huh?
It is water body. It is Khal.
Khal is not water.
Yes, then Doba is water body. Next page, my Lord,
Khal
page
is-
146.
Khal
Page
is farther away from my hotel.
Page 146.
My Lord,
Lord,
an
that
inquiry has
answer is
to-
also there. Page 146.
My lord, an
Doba.
inquiry has to be. My lord, let an inquiry be conducted.
Yes.
I tell you, Lordship, well, it's not only encroach on the water body. As a matter of fact, extra floor has also been done.
And you have sealed the building.
Yes, I have issued demolition order. Well, we are law abiding. I'm just waiting when an expedition is pending. That is why we have not stayed. Just Lordship's also.
My lord,
will do that.
and before further submission,
Not only
this
enforcement of
particular
water body.
person who has brought this PIL happens to be my landlord. And there is a civil litigation, that is TS case number being filed, that is pending in Kolani court. And this is all done
Landlord in respect of some other property.
some other portion. And not only that, he has made certain allegations tarnishing my business, like I'm doing
I knew
trafficking,
this question would come up, my Lord.
flesh trade, and that has been circulated in Facebook.
Lord, kindly have a look at this judgment.
And there
Lord, this issue, my Lord, the
there
Honorable
happens to be a
Supreme Court has
private
decided. Kindly
agenda.
take, my Lord, paragraph 36.
And they're
Lord,
harassing my client.
at least my case is better than what it was in paragraph 36 before the Honorable Supreme Court. 37(1) SCC 227. Lord, the three-judge bench, my Lord, decides this. Paragraph 36. The allegations made in the petition disclose a lamentable state of affairs in one of the premier universities of India. The petitioner might have moved in his private interest, but inquiry into the conduct of the examiners of the Bombay University is one of the highest medical degrees was a matter of public interest. Such state of affairs having been brought to the notice of the court, it was the duty of the court to the public that the truth and the validity of the allegations made be inquired into. It was in furtherance of public interest that an inquiry into the state of affairs of public institution becomes necessary, and private litigation assumes the character of public interest litigation, and such an inquiry cannot be avoided if it is necessary and essential for the administration of justice. My Lord, I my Lord, implore your Lordship, my Lord, to apply this, my Lord, to the facts of this case, my Lord, because it is exactly that. Filling up of water body, my Lord, is no mean issue. My Lord, it's a menace, my Lord, through the society, my Lord. Underground water level depletion, my Lord, is something which we are facing every day. My Lord, buildings coming down, crumbling, my Lord, like pack of cards, my Lord, we are facing every day, my Lord, because of water bodies being filled up and construction coming up on that. My Lord, and this, my Lord, I have checked up, my Lord, has been followed up, my Lord, by several, my Lord. I thought I will bring the parent one, my Lord.
Thing is, assuming he's got a private interest, he's got some axe to grind. Still, when there is a blatant violation, the court can always discharge the petition.
Yes.
It can substitute somebody else, or it can convert it into a suo motu proceedings. So this might be one of the reasons, but none of the authorities appear to support your case. But the seriousness of the allegation is that you have not only encroached into a canal, keep the, conversion order aside. If suppose conversion order has so many disclaimers, without prejudice, without prejudice, without prejudice, without prejudice to the Town and Country Planning Act. So if we expand the definition of what is Planning Act, a municipal law governing planning permission also will fall within the umbrella of planning. Because if you don't fall within a municipality, a corporation, then probably your planning approval has to go before the Deputy Director of Town Planning Authority, DDTP. So therefore, they have said that you have forged a revised plan.
My lord, let an inquiry be conducted first.
That is pending in your writ petition. You have to save your skin there. There is no interim order. As on date, all authorities have uniformly said that not only you have forged the revised plan, You have submitted that to various authorities.
And those plans was given to me by the executive officer of
So
municipality.
he also has to go behind bars. They have to inquire.
They have to inquire, sir.
And if the complaint has been lodged, I think FIR would have been registered by now.
We have done so.
And they say that you have got a fake seal of the municipality. That's very serious, madam. All right, leave alone that aspect of the conversion part. What do you say about the encroachment on the canal, which you could not have done?
But canal is not there actually. It is a little farther away.
So
it is
that,
farther.
all these issues,
That has to be.
we can't
the
restrict
same
the
land has
corporation, municipality from proceeding further. Your writ is pending. They are just probably your people have gone and threatened the municipality staff and officers.
No, that has not been
Conversion
done.
certificate shows the same plot. Lord Khal is that Khal only, my lord, and it is for hotel. Kindly take Lord page 144, which my learned senior friend appearing for the state plot said it is not a water body. It is Khal, it is that Bagher Khal only, which is what my lord the municipality says. My lord page 155, ROR Khal, plot number 6, which has been shown by the municipality, my lord, by absolute pinpoint, converted to hotel.
And the other one is also Khal.
Yes, converted to Bastu, homestead. Then my lord the other one is Doba, converted to hotel. My lord at page 146. Two Dobas converted my lord to my lord non-water. Doba my lord something my lord which is my lord below water, underwater.
So this conversion itself is
Yes,
illegal.
and my lord, there is no condition attached to the conversion. My lord, the rules are my lord are screaming at the face my lord of the land reforms authorities that you have to my lord have a compensatory water body. My lord 5A9, 5A sub rule 9. Sub rule 9, my lord, of 5A.
Because we have seen such conversion orders in other cases.
Yes.
There is a specific clause which says that this conversion order will take effect only after you make the compensatory water body and the officer inspects them. Because they will also tell the size, where you have identified the land, etc. We have seen cases. Yes, same Mosa. And who is the owner of this plot number 6?
Devendra
The hotel business my lord is a proprietorship concern.
Plot number 6 is a call.
Yes.
Can there be a private owner of a
Yes,
drainage
that-
channel?
That
That's what Lordship is pointing out.
Yes, but my lord, that gentleman my lord appears to have been the owner my lord because I think my lord,
I don't.
that is what is written there, Lord, because it's owned by him is what has been shown.
Because suppose he says, Red Road, I want to convert into Bastu.
Yes.
He can't.
I quite get that
He
point,
be
Lord.
owner of the property, no?
This conversion order is really something I
One thing, it can also be a forged document.
And maybe my
There
lord.
are chances.
can be.
Or connivance of the ADM.
Has to be.
Then ADM. There are chances. When he can have your office seal, your signature, etc., he will have other things as well.
Our predicament we saw conversion, we granted permission, and after that also well, there is extra floor, extra area, extra everything. That is why we had to issue the demolition order.
This writ petition filed as a public interest litigation highlights a very surprising and sorry state of affairs where power under section 4 capital C of the West Bengal Land Reforms Act 1955 has been exercised, and the additional district magistrate and district land and land reforms officer North 24 Parganas, Barasat, has passed a conversion order converting a plot of land which has been classified as Kal in the record of rights into hotel. In the same plot of land, which continued to remain as Kal in the record of rights, was converted as Bastu. The order of conversion is stated to have been passed on 19/7/2016. On going through the order, we find there are several disclaimers, namely that order is without prejudice to the provisions of Chapter Roman 2B of the West Bengal Land Reforms Act 1955, semicolon. Permission is without prejudice to Urban Land and Regulation Act 1976, semicolon. Permission is without prejudice to the West Bengal Town and Country within bracket Planning and Development Act, Planning and Development bracket Close Act 1979. And the applicant will have to apply to the government for long-term settlement of the land under usual terms and conditions on payment of rent and salami if in future the land in question is found to be vested. Thus, we find the order of conversion is cannot be attached with the full. Cannot be stated to be a full and an order which cannot be interfered or reviewed or um, reconsidered, since there are they are with they have it has been passed without prejudice to several enactments. There is nothing to indicate that the private respondents who were stated to be the applicants had applied to the government for long-term settlement of the land, and what are the conditions, etc. In any event, in terms of the provisions of Section 5 capital A, Rule 5 capital A of the West Bengal Land Reform Rules 1965, Rule 5 capital A within bracket 9 of the West Bengal Land Reform Rules 1965, where the application mentioned in sub rule 1 of Rule 5 capital A relates to permission for conversion of any land having water body of any description or size, the block land and land reforms officer shall also be asked to conduct necessary inquiry to ascertain if the person holding the land identified for creation of compensatory water body has permanent and transferable right, title and possession over such land, and is agreeable for necessary transfer of such land for creation of compensatory water body therein. Full stop. The further the rule stipulates that the district land and land reforms officer shall get the required report from the block land and land reforms officer directly to save time. In the instant case, we find that the order of conversion dated 19/7/2016 does not speak of any compensatory water body. The question of applying for conversion of a property of a water body for some other use can be done by a person who owns the property. If the record of right shows that the plot number 6 was classified as KAL, KHAL, it defies logic that the private respondents could be a owner of a KAL, which is a drainage channel. Therefore, we find serious infirmity in the order of conversion. That apart, there is no whisper about any requirement for providing a compensatory water body. Therefore, we have serious doubts as to the validity and efficacy of the order of conversion. The learned advocate appearing for the private respondent submitted that the present writ petition is not a genuine public interest litigation, since the writ petitioner is the landlord of the private respondents in respect of another property situated in Kalyani, and there is a civil litigation pending before the civil court. In response to this submission, the learned senior advocate appearing for the petitioner placed reliance on the decision of the Honorable Supreme Court in Shivaji Rao Nilakekar Patil versus Dr. Mahesh Madhav Gosavi and others, 1987 1 SCC 227, wherein the Honorable Supreme Court held, even though the petitioner might have moved in his private interest, but inquiry into the conduct of the examiners of the Bombay University, therein, was a matter of public interest. And such state of affairs having been brought to the notice of the court, it was the duty of the court to the public that the truth and validity of the allegations made be inquired into. Full stop. Further, it was held that in furtherance of public interest, that an inquiry into the state of affairs of public institution becomes necessary, and private litigation assumes the character of public interest litigation, and such inquiry cannot be avoided if it is necessary and essential for the administration of justice. The above decision would support the case of the petitioner. Even assuming the bona fides of the petitioner are in doubt, nothing prevents this court from discharging the petitioner or substituting the petitioner or converting the present proceedings into a suo motu proceedings. Therefore, the objection raised by the private respondent, learned counsel of the private respondent, regarding the maintainability of the writ petition stands rejected. That apart, we found that the Howrah Municipal Corporation has already issued, already sealed the building, issued demolition order, and has also lodged a complaint before the officer in charge, Alisara Police Station, on 12/9/2024. By going through the complaint, we are surprised to find that the allegation against the private respondent is that they are in possession of a forged revised sanction plan in respect of premises A. And this, according to the municipality, has been created by the private respondents. Further, in respect of premises B, it is stated that forged revised sanction plan replicating the stamp and signature which was attested and affixed in the backside of sanction plan issued in respect of premises B, so as to portray that the revised sanction plan is in respect of the premises A, which has been allowed, and thereafter using the forged document before various of government officers to obtain licenses and permission so as to carry on the business in premises B. One more very serious allegation is that the private respondents are also in possession of counterfeited seal of Halisara municipality and other instruments which were used to manufacture the forged revised plan. And this, according to the municipality, has been for the purpose of cheating and no, strike out that. It is not clear as to whether the complaint has been registered and an FIR has, whether the complaint was inquired into and whether an FIR has been registered. If not done so, the officer in charge, Halisar police station, is directed to inquire into the complaint. Oh, sorry, sir. Please strike out that. The complaint has been received by the concerned police station and PS case number 240 of 2024, dated 12/9/2024, under sections 338, 336 within bracket 3, 340 within bracket 2, 318 within bracket 2, 61 within bracket 2, and 341 within bracket 1 of BNS 2003 has been registered. We direct the officer in charge, Halsara police station, to complete the investigation at the earliest and file charge sheet in the said proceedings, if not already filed. Thus, all right. It is submitted by the learned advocate appearing for the private respondents that they have filed a writ petition before this court, before the learned single bench of this court, in WPA 22697 of 2024, wherein they have sought for a direction as to why their representation should not be disposed of by extending an opportunity of personal hearing, and for a direction to consider and dispose of the representation. And also for a direction to cancel/rescind the memo dated 31st August 2024. Where is that 31st August 20?
That is the demolition order,
which is a demolition order.
71.
Which is a demolition order. As on date, the writ petition is pending and there are no interim orders. If that be the case, there can be no fetters on the Howrah municipality to proceed Halisar municipality to proceed further in pursuance to the notices which they have issued and take the matter to the logical end. One more objection that has been raised is stating that the order of conversion, which was passed in the year 2016 by the additional district magistrate and district land and land reforms officer, North 24 Parganas, continues to remain valid. In the preceding paragraphs, we have mentioned that the question of converting a call into a hotel or bastu would not arise. Apart from that, there is no direction for compliance of the statutory requirement as provided under Rule 5 capital A within bracket 9 of the West Bengal Land Reform Rules 1965. Another conversion order has been passed where the land which was land in plot number 5 and 9, which were classified as Zoba in the record of rights, have been converted as hotel, bastu. This order also would suffer from a similar illegality as this order dated 5/9/2016 also suffers from the same illegality as that of the order dated 19/7/2016, and the illegality is apparent on the face of the order. Therefore, the question of relying upon such an order by the private respondents would not in any manner advance their case. We also have a genuine doubt as to whether the order of conversion, which is relied on by the private respondent, whether the two orders of conversion itself is a valid document or whether it is also a case where forgery has been committed. We do not wish to comment further on this matter. Thus, considering the seriousness of the issue, we direct the Halisara municipality to proceed further pursuant to the memo issued on 31/8/2024 and Take the matter to the logical end within a period of 4 weeks from the date of receipt of the server copy of this order. One more thing he said. Before that, sir, the learned advocate for the municipality submitted that even as per the forged revised sanction plan, there is a limitation of the number of floors to be constructed, but additional floors have been constructed, which is another illegality committed by the private respondent. With the above direction, the position stands grateful.
Lord, the affidavit of service will not be required.
I'll be failing in my duty. One case I was trapped. One of the honorable judge directed to file charge sheet. Ultimately, it was found that the case is false. So he would be bound to file charge sheet. If necessary.
Then no, this is where municipality.
He is pointing out, Lordship has said complete the inquiry and file charge sheet. He is saying that if any charge sheet, if any after conclusion of hearing this,
otherwise
towards be added. That's
all right. Complete the investigation and proceed in accordance with law.
Lordship, grateful.
Like the charge sheet and proceed in accordance.
Stop with this, sir. Okay. Meeting is this judgment.
Lord, we have filed our affidavit of service.
Affidavit of service kept on record.
Grateful.
So certain other matters where the conversion order was passed 15 years, sir, as appeal, 15 years, 20 years back, compensatory order body ordered, that was inspected, then
litigation, I usually don't come, Lord, because I know the limitations. But this was a bit.
client can move for anticipatory claim. Powerful, her client can move. That lady, what she wants.
নদিয়াতে এই প্রথম ৪৫ বিঘা জমির উপর তৈরি হতে চলেছে বসবাসের সেরা পরিবেশ বৃন্দাবন গ্রিনস। অর্থমন্ত্রক ভারত সরকারের নিলামী প্রক্রিয়া দ্বারা অনুমোদিত জমি এবার আপনার হাতে তুলে দেবে লাখুটিয়া গ্রুপ, তাও আবার অল্প মূল্যে। এখানে একেবারে মনোরম পরিবেশের মধ্যে থাকছে পুজোর বেদি সহ মন্দির, জলাশয় ও সুইমিং পুল, সিটিং এরিয়া, ওয়ার্কিং এরিয়া ও চিলড্রেন পার্ক, কমিউনিটি হল ও জিম ছাড়া আরো অনেক কিছু যা আপনার জীবনযাপনকে বানিয়ে দেবে অতি উত্তম। নদিয়া জেলার মদনপুর স্টেশন থেকে মাত্র 2 মিনিটের দূরত্বে আলাইপুরে এই বৃন্দাবন গ্রিনসে একদম অল্প মূল্যে জমি কিনতে শীঘ্রই যোগাযোগ করুন এই নাম্বারে। সীমিত সময়ের জন্য কিস্তিতেও দেওয়া হবে জমি।